Welcome, everyone. Thank you for joining us for today's Appraisal Buzzcast. I'm Jim Morrison, and with me, as always, is our host, Hal Humphreys. Let me bring him in. Hey, Hal, how are you doing?
I'm good, Jim. How are you today?
I'm doing great. We have a great episode today. We have somebody who we actually haven't had on a Buzzcast before, but I'm very excited to interview. We have Craig Capilla, the partner of who's a partner of Franklin, Greenswag, Channon, and Capilla, and one of the leading lawyers for real estate appraisal industry. Let me bring him in. How you doing, Craig?
I'm great, Jim. Thanks very much for having me on. Hal, good to see you.
Craig, always good to see you. You know, we haven't had you on the Buzzcast before. So for our listeners that might not be familiar with Craig Capilla, tell us a little bit about your history and how you ended up working as a lawyer in this real estate appraisal space.
Absolutely. So I have spent the last 12 plus years at some iteration of the firm I'm at now. We went through a merger and kind of a reshuffle about 3 years ago. But prior to that, I was still basically in this same spot. And I've spent that time traveling all over the country, defending brokers, defending appraisers in license law cases and in lawsuits. Prior to that, I worked for the licensing agency in the state of Illinois, and I was one of their board prosecutors for about 4.5 years. All of this was exactly according to my plan, which is a complete lie. There was no plan. I was actually a transactional attorney, as it turns out. That's where my career path was going to take me. And in the fall of 2007, the transactions that I was working on sort of came to a halt. I needed a new place to land. And so I took a job as a board prosecutor for the Illinois licensing agency, and I had a bit of a real estate background, so I went into that field. I started that the Thursday before Bear Stearns collapsed, and the rest of that brings me here.
So you got kind of you switched jobs and had a baptism by fire.
Exactly.
Oh, wow. So 2007, you start the job. 2008, the entire real estate appraisal community is in an uproar because everybody's being accused of all manner of malfeasance. You spent time, you said 4 years working as a board prosecutor. Tell us a little bit about what that means.
Sure. So while I was with the department in Illinois for all their licensing from March of 2008 until October of 2012, I was there prosecuting cases that involved anything that was tangential to real estate in their licensure division. So it was appraisals, real estate brokers, home inspectors. We even had timeshare and land sales at the time. We had a mortgage fraud task force then that worked with also all of the mortgage banking, loan originators, and then that grouped in with state and federal law enforcement, DOJ, HUD's Office of the Inspector General, FBI. Actually had the occasion to work with the Secret Service briefly when, so as it turns out, mail fraud is their sandbox. It's only wire fraud that goes to FBI.
Okay. Interesting. Well, so there may be some people out there that think, oh my gosh, this guy was out there prosecuting real estate appraisers, which is true, but
Accurate.
Now that you're out of that role and you're in private practice and you're defending appraisers, do you think that gives you maybe a little bit of a leg up in negotiating on behalf of appraisers with board prosecutors?
Well, and I think that is correct. I think seeing what I've seen as a prosecutor and then trying to apply that same thought process to advocating on behalf of appraisers now and trying to help negotiate a resolution to their cases, I think has been helpful. And frankly, when I'm looking around the country at other folks who are similarly situated to me, there's not that there's a whole heck of a lot of us, but one of the common threads that tends to help this are people that have that understanding of how the administrative agencies work, how their prosecutions go. And even if they don't necessarily have a whole lot of substantive experience, maybe in appraisal, they have an understanding of how the game is played at that level and can make much better advocates for whoever the professionals are that they're representing.
I love it. Well, let's do this. I'm going to take a quick break and we'll hear from one of our sponsors and we will be right back.
The Dictionary of Real Estate Appraisal, 7th edition, is a landmark text that reflects the depth and breadth of appraisal knowledge. Each entry, definition, and reference has been painstakingly researched and designed to reflect an expert understanding of issues that currently impact the profession. The new dictionary is an essential authoritative resource for all appraisers. The dictionary is divided into 2 sections, an alphabetical listing of terms directly related to real estate appraisal, and an addendum with topical glossaries and compilations of terms used by related real estate professionals. Find it at appraisalinstitute.org/dictionary7.
Welcome back, everybody. You're listening to the Appraisal Buzzcast. I'm Hal Humphreys, your host, and I'm joined today by my good friend, Craig Capilla. Craig, we just saw you at the ACT show out in Colorado Springs, and I think we can safely say everybody had a good time. One of the highest rated sessions of the conference was the mock trial session, where you were part of a defense team, a mock defense team, defending an appraiser. There were 2 scenarios presented. One was where an appraiser represented themselves, and the other was where you were representing the appraiser at a board hearing. If an appraiser ever finds themselves in this unfortunate situation where they need to defend themselves, what advice would you have for that appraiser?
So first and foremost, the number one thing to keep in mind for somebody who is facing a board complaint, an inquiry, you get that sinking pit of the stomach feeling when the email comes in or the certified letter comes in and says, hey, we've received a complaint against your license for an assignment that you did at XYZ Avenue. It's take a deep breath, stop, take a deep breath, don't react immediately, and assemble your team. And that means contact your insurer. Let your errors and omissions insurance carrier know about it right away. If you read the fine print of the policy, which I encourage everybody to do at some point, you do have an obligation to do so. In order to preserve your coverage for all matters, you've got an obligation to notify them that this circumstance has arisen. And then you want to put your best foot forward before you respond. More often than not, the appraiser who sits down angrily that afternoon and goes, well, I'm going to tell them what I feel about this complaint, winds up in a spot of trouble. And it can go one of 2 ways. It's unnecessarily harsh and abrasive, and they're taking their frustrations out on the poor government employee whose job it is just to send this generic notice to everybody who gets a complaint. That doesn't help move the ball forward. Or it's the immediate, oh my goodness, everything's terrible, the sky is falling, I can't believe I made this mistake, and they've confessed to the Lindbergh baby by the time they're done with page 1 of the letter. Either way, that's not going to help you in the long term. So stop, take a breath, notify your insurer, and get your team assembled. If you don't have a team, your insurer may be able to point you in the right direction of someone, but they may not always have the best available resources for that either. So, for anybody who's listening to this, for anybody who's reading the magazines that come out, there are sources available. There's a handful of us that do this. And if you've ever gone to any of the major conferences, you've probably seen all of us at some point. Reach out to any of us. We're all here to help get you pointed in the right direction.
And the question comes up a lot of times, I'm an appraiser, I've got a board complaint filed against me, I'm going to have to go to this hearing. I'm afraid to hire an attorney because I think the board's going to take that the wrong way. They're going to come at me harder. What is your advice to an appraiser who's looking at that situation? Should they just hire an attorney that they know and like? Should they seek out someone like you or the other folks that we know that speak at these conferences on a regular basis, that deal with real estate appraisal issues on a regular basis? Should they reach out to an attorney up front?
I would think so. If you have one available that that understands the process of these particular kinds of cases, don't pass go, don't collect $200, pick up the phone, call them right away. If you're not sure where to turn, if you don't have somebody who has that knowledge base, but another attorney, reach out to them and ask them if they know somebody who does this sort of thing. But you can't also go out and find just any old attorney and that'll do in a pinch. I have seen that cause more harm than good on occasions. But don't try to go it alone. Reach out to your state coalition if you have one, if you're a member of one. If you're a member of a professional organization, if you are, I know one of the sponsors that you all have is the Appraisal Institute. If you are an Appraisal Institute member, reach out to them. They can help guide you and point you in the right direction. You don't have to tell them everything that's going on. You just say, hey, I've got something that's come up. I need to find an attorney that understands how the appraisal stuff works, and they can likely get you pointed towards somebody that can assist you. But don't go it alone. Don't try to do this all yourself. It doesn't work well that way. I used to tell that to people all the time when I was still a prosecutor. People would come in and they would ask, well, do I need an attorney for this? And in every courtroom we had when I was working for the state board, on the wall, we had a sign. It said, serving the people of the state of Illinois. I used to point them to that sign. And I said, what that means is right now, I represent every single person in the state of Illinois, except for you. So whatever you want to do with that information is yours, but think about it for a minute before you go forward with this. And then that's true if you find yourself in those circumstances. It's a common misconception. Well, if I get a lawyer, then they're going to think that means that I did it. No, think of it this way. You're walking into a situation where they're bringing at least one, if not more, lawyers. Why wouldn't you bring one with you?
Yeah, I think, I'm not an attorney. I do not offer legal advice. And what I'm about to say is in no way legal advice. This is Hal, real estate appraiser, offering my idea of a best practice if you get a board complaint filed against you. Number one, your heart rate is going to go up the second you get that registered letter. So take a minute to, as Craig said, catch your breath, take a breath, breathe, remember to breathe. Number two, you've got to notify your insurance carrier, let your E&O insurance know what's going on. They may offer the services of an attorney, but my thought is that attorney is hired by the E&O insurance company, paid by the E&O insurance company. I don't feel like that person necessarily has my best interest in mind. So I'm going to personally reach out to an attorney that will be my attorney and have nothing but my best interest at heart. Does that sound like decent advice from one man to another or one human being to another about a situation like this?
Absolutely. I think that makes a ton of sense. There always is that concern when it's a panel counsel assigned by an insurer. Who do they really work for here? And we don't have nearly enough time or the complexities to go into the tripartite relationship. We're not going to do that today. But the reality of it is, it's about a comfort factor too. And you want to know that whoever you have is 100% in your corner and working to benefit your interests. And I think you've got a great point there, Hal.
Okay, well, let's do this. Let's take a real quick break and hear from one of our sponsors, and we will be right back.
Need a profitable PDC solution for your clients? Jaro's appraisal management software makes the process faster and easier. With Jaro, you can order standard appraisals, inspections, and hybrids, all on one seamless platform. The software also gives you everything you need to manage new vendors by taking care of background checks and letting you shop from a pre-vetted panel of inspectors with a wide range of credentials. Get started with Jaro today at tryjaro, that's tryjaro.com.
Welcome back, everyone. You're listening to the Appraisal Buzzcast. I'm Hal Humphreys, your host, and I'm joined today by Craig Capilla, attorney out of Illinois. Craig, we were talking before the break about, should I not hire an attorney? I'm going to dive back into that just a little bit. If I'm going to hire an attorney, and I'm just going to say my thoughts, you tell me what you think of them. What I'm looking for is attorneys, by and large, are paid really good money to know the law. Most attorneys do not understand the ins and outs of real estate appraisal theory or real estate appraisal regulation. So what I'm looking for is an attorney who does understand those things. Barring that, if I'm in a state where no one is qualified, they can't get, brought on to serve on my team, I've got a local attorney that I really like, smart attorney, knows the law inside and out. I'm going to hire someone to help that attorney understand real estate appraisal theory, real estate appraisal, regulation issues, and most importantly, USPAP, USPAP, because again, I don't usually pay an attorney for understanding USPAP. I pay an attorney for understanding the law and how to apply it. Is that sound logic on my part?
Again, 100% agree with you on that one. We've kind of given reference to the fact there's only a small handful of attorneys out there that truly speak USPAP. There's just not a lot of us. And which makes sense sort of as just an extrapolation of there's only X number of appraisers across the country anyway. The sandbox really isn't all that big. But you may find yourself then in a jurisdiction where we really don't have any coverage for this, where there is that expertise found in the lawyer. So what you're more commonly going to find is exactly as you said, somebody who has more expertise in understanding the law that's applicable to that. It might be somebody who has a deep bench of knowledge in administrative law and license law and those proceedings. If you find yourself in a lawsuit scenario, it might be somebody who has a really strong background in contracts cases or negligence or negligent misrepresentation, malpractice claims, that understands the nuance of all of that. But the actual subject matter expertise in appraising and USPAP may be lacking there. And so in those instances, it can be crucial to have somebody on your team that also has that subject matter expertise as well. And now that may be in the form of a testifying expert, should you end up litigating the matter. But even if you get that far, you might still want somebody else in your corner who's not going to get put in the hot seat, but who can help also guide your counsel strategically. And so in cases like that, you may be looking somebody as a consultant who can help educate the attorney about the subject matter concerns. And look, I'll come right out and say it. I do consider myself to be in that small handful of attorneys that can at least be conversant in USPAP. I still use consultants. I'm never going to know the book and the application of the theory as well as somebody who lives and breathes it every hour of every day. So some people think, well, doesn't that start to challenge the territory of the attorney? And do they get, a little bit protective of their space? Some may. And frankly, that's maybe not the attorney that has your best interests at heart then. But it's absolutely no skin off my nose to be surrounded by people smarter than me. Not only is it very easy to be in a room where everybody is smarter than me, but it's something I look for. I mean, if I can have that going for me, I'm going to feel very comfortable in the situation that I'm in. I don't have any reluctance for that. So I like to use consultants. I like to use experts just to make sure that I'm not missing anything. As well as I may think I know it, it's not the end all be all.
Yeah. I like it. Okay. Well, I think we can kind of put the stick down and step away from the horse on those issues. One bit of advice, just one bit of advice. And I've got a bit of advice I'm going to give to this, but how do you avoid the board complaint in the first place? And if you do get one, are there any things that you can do to avoid ending up in court over a board complaint? Now, my advice for how do you avoid the board complaint in the first place, you may not be able to. Anybody can file a complaint against you, the appraiser, at any time they want to for pretty much any reason they want to, and there's nothing you can do about that. How can you avoid the hearing process driving you to end up in a court of law? From my perspective, I'd say hire an attorney, get your E&O insurance involved and address the issues professionally, sensibly, reasonably, and try to answer everything you can in the first place that is reasonable. Again, so what is your advice, Craig, to someone? Number one, how do you avoid a complaint?
So I'm very much in agreement with you on this. There is no silver bullet here. There is no surefire way to avoid the complaint. I will say the overwhelming majority of complaints that I see come across my desk are often rooted in reporting concerns, or put more simply, the appraiser writes their report and turns it into their client in such a way that it leaves questions in the mind of the reader. Now, that's a little bit difficult because throughout all of this, I commonly find that appraisers do have an understanding. Here's what I did. Here's why I did it. Communicating that, putting that onto the page is the part that becomes challenging. And so that is a blind spot. It's a natural blind spot for folks. Sometimes it helps to have a proofreader before the thing goes out, because somebody will look at this and go, I'm not sure what you were trying to say here. And if you fix it on the front end before it goes out the door, that can help eliminate a lot of problems. The key is answering questions before a reader has an opportunity to ask them.
In the world of writing, and my wife is a writer. She writes for publication, for news outlets, public radio outlets, newspapers. She's written books. The thing that they talk about in that writer's circle is the curse of too much knowledge. You've done the research, you've done the study, you've done all the stuff, you say the thing, and that's why writers have editors to say, oh, you need to explain this a little bit better because you know it, you understand it, and in your mind, you're seeing the whole picture, but you haven't articulated it. So I think that's a really clear thing, is a good thing to say, is explain it up front, help an ounce of prevention, basically.
That's absolutely right. And that really does go a long way in mitigating the risk. Although we know that there is no really perfect report out there. And at some point, somebody who's grumpy that the appraiser was 15 minutes late and tracked mud on their carpet can go ahead and turn a report in anyway, even if it's a just meticulous report. So if you find yourself in that spot, no matter how well you may have written the report on the front end, you might still find yourself answering some questions on the back end. And if it comes to that, I think, Hal, your points again were very well made. You know, one of my partners, Charlie Franklin here, is one of the founders of this firm and used to defend appraisers against me when I was prosecuting. That's how Charlie and I got together on all this stuff. One of the things that he went out on the circuit and talked about for years while he was still coming to these conferences and doing these things was he's got this Charlie Franklin's 3 C's of dealing with regulators. And it was candor, contrition, cooperation. They've got a job to do too. They've got to investigate this and let it take them wherever it may go. So there's no use being combative. That's almost a surefire way to throw gasoline on that fire, escalate this, and now get it in a more litigious posture. 85-90% of what I work on gets resolved without getting inside of a courtroom because, one, we know the playbook, we understand the processes, and now we can sit down and go, okay, you're going to have these requests for us. Let's get to work on those. Let's respond to your reasonable requests. Let's get you what you need to do your job. And it's about taking the temperature down on it too. Most regulators, particularly on the investigative side of the coin, really are there to just gather evidence, gather facts, and then get it off their desk. Send it up the chain to somebody else who can make a decision. There's no use beating them with a stick. It's not going to do you any favors. And when there may be a gray area, it could go this way, it could go that way, that little bit of candor and contrition can help engender some goodwill. And in that case, tie goes to the base runner in that scenario. So there's a reason to be forthright, be earnest with them. There's a difference between saying, there's some things here that going forward, I think I'm going to change and try to do better, as opposed to, oh my God, I can't believe I got all this wrong. Those are two sides of the same coin. we encourage the improvement angle out of all of this, but it's also, there's no use sticking your head in the sand and trying to avoid it. Work with them, make their job easier, and don't become the folder on their desk that they remember.
I love it. The 3 C's. I wrote these down: candor, consternation, and combativeness.
Exactly. Got it in one.
What are the 3 C's again?
So that's candor, contrition, and cooperation. Or
Look,
you can boil it all down into one. Don't be a jerk.
Yeah. And look, at the end of the day, for appraisers, if a complaint has been filed against you, this is potentially your livelihood at stake. It's not the time to go in chest thumping and knocking things over. And it is a time to get a team together and approach it with a clear head. And, if you made mistakes, I mean, I love the thing you said, Craig, about, going forward, I've learned some things that I will probably do differently now. I think that's a great way to approach it. And look, we're all lifetime learners. We're all learning on a daily basis. Does it hurt your feelings if someone complains about your appraisal? Yes. Does it make you feel, I mean, look, if you get a complaint filed against you, you go through this motion of, I should have died when I was a child. I should have been smothered in my crib. I'm a horrible human being. I should never work in this business again. Go through that on your own time. But come to the table with a team that can help you, again, let's do the 3 C's one more time, Craig.
Absolutely. It's candor, contrition, and cooperation. It's being candid. Hey, this is what I have here. Here's what I did. Here's why I did it. It's contrition. It's, this wasn't my best day. I can do better work. I will do better work. Since that date, I have done better work. And it's cooperation. I know you've got a job to do. I look forward to working with you in getting this file resolved and off your desk so that you can move on to other things. And at the end of the day, for the recipient of all of this, for the appraiser who's called into question, the stages of grief are a very real thing. And part of my job is addressing that too. I mean, sometimes it's a sales job, sometimes it's a therapy job. We get all of those facets of it. It's not just law. But it's important to understand we have to work through all of those things. So when we are dealing with the regulator or when we are dealing with an opposing party, we can be putting our best foot forward and be prepared to face the day.
I love it. Craig, thank you so much for taking the time to be here and to talk about these issues. I think this is one of the more important things that we can talk about with appraisers is, how to stay out of trouble if someone turns you into the state for whatever reason, if they're mad that you didn't give any value to the koi pond, which was a custom koi pond built with Jethro and a shovel and a visqueen plastic. And it was basically an abattoir for goldfish. I mean, that's fine, but complaints happen. People get mad, people get upset. And I think it's important for appraisers like Craig, the number of times I've sat through, especially early on in the game, a USPAP class where the instructor just terrified everybody in the room of like, you're going to, and you leave these classes thinking, oh my gosh, I don't ever want to do another appraisal again. Do the work, do good work, do it in good faith. Do the best you can. If a complaint is filed, gather your team. Jim Morrison, do we by chance have an anonymous appraiser that Craig Capilla and I could try to tackle?
Yeah, this is a really great one. And for anybody out there, I know we got a lot of people when we were at AXE that said, this is one of their favorite parts is hearing the questions that we send in because our experts all offer such great advice all the time. So we appreciate that. If you have a question, reach out to us at comments@appraisalbuzz.com. So this is a 2-part question. It says, there will be a 200-foot tall cell phone tower being constructed behind our neighborhood, and it's about 300 feet from our homes. The appraiser of the cell phone company stated that there would be no loss of value, even though this view would be obstructed in several backyards. So the first part is there really no value change to a home by adding a cell phone tower in our backyards? Isn't this similar to adding power lines into our backyards as far as a reduction of home value? And the second part is the appraiser who wrote this report has a valid license in our state, but the employer has an involuntary inactive designation. Are employers required to have active licenses? Hal, let's start with the first part.
So the first part, I have the answer to the first part, and that is, it depends. It just depends, right? I mean, it always just depends. Does a cell tower 500 feet away from your house negatively impact the value? I don't know. Maybe it does, maybe it doesn't. That is the work of an appraiser. Someone is going to have to go out and analyze the market, find other homes that have had cell towers built behind them or similar obstructions to the view built near them, and see if there's any impact on value. My gut says, yeah, I don't want to live next to a cell phone tower, but I'm not appraising your house based on my gut. I'm appraising your house based on factual data that I've gathered from the market. So if there's a cell tower and I can find in the market a reaction to that is negative, then I'll report that. But it really does depend. Sometimes it does not have any impact on value. Clear as mud?
I think that about covers it. First of all, it depends. I'm supposed to be the lawyer here. That's my answer, Hal. That's how this works. I will say that I have been involved in cases that involve windmills. And so that's probably all I'm going to say about that. But as we know, your mileage may vary as far as impact to value in those sorts of cases, surely with cell towers as well. I found the question regarding the involuntary inactive status of the employer to be an interesting giveaway. First thing that actually tells me at this is a question coming out of the state of Florida, whether or not we know the person involved. This may be anonymous, but involuntary inactive is a very Florida pointed thing when it comes towards licensure questions. And so my answer to the question about are employers required to be active licensees as well, I'm going to steal from you, Hal, and I'm going to also say it depends. In some states, that can be a concern. In some states, the employer in this may be regulated as well. Now, we don't know in this instance whether we're talking about an individual supervisory appraiser with knowledge and expertise, what I would affectionately refer to as a right side signer, if you're envisioning the signature page of a GSE form right now. Surely we're not doing this assignment on a GSE form, right? Because those are only for mortgages. So we're going to avoid that here. Does the entity have to have a license and does it need to be active? Now, I'll tell you, in Illinois, in Wisconsin, and some other states where I am, no, not at all. They don't need to have a license any way, shape, or form as an entity, as an organization. Only the individuals need to be licensed. And so if in your state, wherever you may be, this scenario arises and the appraiser individually has an active license, very well may be sufficient. In a case-specific item such as this, there may be some question as to whether or not the entity is in good standing, but that's more of a question at lawsuit time. Is there actually corporate protection? Is there limited liability? Is there a pot of gold at the end of the liability rainbow if it escalates into a lawsuit? For licensure purposes, just the fact that the individual is licensed and certified, who has completed the report and represented that it is their work product, that's usually enough to be sufficient here and control.
Very good. I love that answer, and I love the fact that your answers are always so much more eloquent than mine. I will say this, Craig mentioned, I've worked on cases that involve windmills or whatever. I worked on a case with an attorney a couple of years ago where an appraiser in a courtroom setting was noticed as an expert witness, and the appraiser said in their expert witness notification that they were going to testify that the goings on at the neighboring property negatively impacted the value of the subject property. And long story short, the attorney that I was working with, first question out of his mouth was, have you done a market study on this property for this issue? And the appraiser said, no, I'm going to testify based on my years of experience. And the judge said, well, thank you, Miss So-and-so. You have nothing else to offer these proceedings. Going back to the notion of it depends. Does something adjacent to or nearby a property negatively impact that property? You don't know unless you do the research and the analysis to say yes or no.
Well, I think that was a great answer. And Craig, I know from the email signature that was in Florida. So thank you for putting up. We didn't name him, but yeah, it was a Florida person. So thank you for that.
And that is another illustration of why you hire an attorney who understands the real estate appraisal business, because this attorney sitting right here with us today picked up on that little bitty scrap of information and said, this must be a Florida case because of this specific language. Look, guys, if you're going to hire an attorney for a board complaint, find someone that understands the real estate appraisal space. If you're dead set on hiring your next door neighbor's dog's previous owner who comes highly recommended, that's fine. At least get one of these guys to consult with you. Craig Capilla is an excellent choice if you decide to go that way. So do we have anything else we need to cover today, Jim?
No, thank you so much, Craig. I'm ashamed we haven't had you on earlier, and we'll make sure that your next episode's a lot sooner.
Well, thank you very much for having me. I appreciate it. I always love coming and doing this stuff, so it's great to be able to chat with you both for a bit.
Craig, thank you so much. And if we have nothing else, on behalf of Craig Capilla and Jim Morrison, I'm Hal Humphreys, and that is your Appraisal Buzz for this week.